Good morning, everyone. Let's get this session 2 started. My name is Hiro Tsukamoto, a partner of Nagashima Onatsumatsu New York, and I'm a moderator in this session 2. Today, session 2, we have the session titled "New Economic Crime and Corporate Transparency Act in the United Kingdom." Obviously, we are going to discuss this act and important crime which was enacted by this act in this session. In this session too, we have 4 distinguished panelists. And from your very left, we have Mr. Ben Morgan, and please let me use my cheat sheet. Mr. Ben Morgan. Ben is a partner at Freshfields, and he is a part of Freshfields International Corporate Crime Group. Then we have Ms. Lisa Ofsky. Lisa is a partner and managing director at Alex Partners, and prior to joining Alex Partners, Lisa served as the director of the Serious Fraud Office in the United Kingdom. And in the middle, we have Mr. Simon Erie. Simon is a partner at McDermott Gould & Emery, where he serves as co-head of the Global Investigations and Compliance Practice. On my direct right, we have Mr. Edward Edward. And Edward is now in the House of Lords in the United Kingdom, and he has been developing the Failure to Prevent Fraud Offense as part of this Economic Crime and Corporate Transparency Act. We have 15 minutes session, and I will do my best to secure some minutes for the Q&A in the end, but please feel free to raise any questions if you have. And with that note, let's move on to the substance of the discussion. As a starter, we or I would like to set the foundation, and as a background, we would like to know what the challenges the United Kingdom had in corporate crime enforcement, and how this new act, ECCPA, could change the situation. And Lisa, let me ask you first, can you kindly explain the situation of the corporate criminal enforcement in the United Kingdom before the introduction of this act?
Yes, thank you very much, and thank you all for your hospitality here. It's a wonderful setting, and we really do encourage questions, so don't be shy. I actually had my own prepared thoughts about what the biggest challenges are, but as I watched my former fellow US practitioners from DOJ leave the stage, I thought, what were the biggest challenges running the Serious Fraud Office in the UK? Well, we don't pay whistleblowers. We don't flip people on each other unless we're in a mafia type context, and it is really not, it is frowned upon. It's not welcome to get folks within the business sector talking about each other and divulging all. So I think my initial thought was some of the biggest challenges is I didn't get all the tools I used to have in my toolbox when I started as a US prosecutor and an FBI deputy general counsel. But in fact, one of the biggest challenges that faced me when I came in as director involved a case that had just been settled right before I took my seat. I couldn't have had worse timing in this way, but it made me realize just how tough the identification principle was for a prosecutor. And what it means in the UK is that you can't get or couldn't, and Edward, I think, will give us more on why it's going to be new and different, but you couldn't get a corporate in the dock unless you had the controlling will in mind in the dock. And the case that really brought home how difficult it was going to be for me bringing corporate fraud cases was the Barclays case, where the SFO, I was accused, Barclays had been a client of mine. I had nothing to do with it, but the SFO had indicted, charged the company and senior individuals, And the level of seniority of individuals in that case was including the CEO of Barclays, the head of investment banking of Barclays, the head of the private bank of Barclays, and the head of financial investigations group. And if you tell me those aren't important senior officials who just might know some way about how Barclays is going about its business, I'm going to tell you that is, it's a long stretch, in my view, from the perspective of where we've come now to say you didn't have the important C-suite in the dock, and therefore you might actually have a case against the corporate. But in fact, the case against the corporate was dismissed shortly before I got to the office. And that was a realization for me that it was going to be difficult to make corporate cases in fraud. It was different in corruption because we had the UK Bribery Act in 2010. There's a failure to prevent offense, which means that you're guilty if you fail to prevent the offense. You have a complete defense if you have adequate procedures, but that has not been tested in the courts. And we also, one sort of positive thing is, thanks to Lord Garnier, we had a deferred prosecution agreement tool that was brought to the country in 2014. And if you look at the deferred prosecution resolutions, and there have been 13 of them, 12 done by the Serious Fraud Office, one, Max, the head of the DPP, just came along at the end of last year to do his, but we had 8 under my tenure, 4 under the tenure of my predecessor. 8 of the 10 involved the failure to prevent offense, and they're in the bribery and corruption world. One last bit I'll add, in case it's helpful to the audience, is our numbers aren't quite what you get in the US. So for example, the 13 DPAs came over roughly 10 years. That's just about 1 a year, 1 plus a year. I think when Edward brought the tool into effect in the UK, he was expecting a lot more activity there. Initially, there was a lot of self-reporting when the law first came into effect because companies were scared. That diminished over time, and sadly, I saw some of the diminution. I'm hoping for my successor that we get a revival in the fraud area now that the law has changed. But we have brought some significant prosecutions and convictions. So we brought the Glencore prosecution, which is the largest corporate conviction in UK history. It brought with it the largest confiscation after a corporate conviction in UK history. And we had a successful corporate conviction of GPT, which was a subsidiary of Airbus. Airbus was the blockbuster DPA that brought in billions, including about $1 billion UK to the Treasury. And the other couple of important corporate convictions that one other that I was involved with involved Petrofac. And the important thing about these 3 convictions is they all involved bribery and corruption. So my highlight message is bribery and corruption has worked on a certain track, and I think it's very much benefited from the kind of changes that we are starting to see on the fraud arena. And I think my colleagues will be able to share a lot in that regard.
Well, thank you, Lisa, for your explanation about the situation in the United Kingdom, particularly before this ACCTA was introduced. Perhaps we should have, totally separate session to discuss the necessity of the bounty, to be paid for the whistleblowers. Edward, then could you kindly tell us how this ECCTA would change or improve the situation that Lisa just explained?
Well, Lisa and I suffered from a serious problem. When I was in office between 2010 and 2012 as the Solicitor General, and when she was in office as Director of the Serious Fraud Office 7 or 8 years after that, we suffered from that hideous complaint, which is called ambition and wanting to get things done. And unfortunately, the machinery that we had available to us was essentially Victorian. And so when you come to look at ECTA, as we call it, the 2023 Economic Crime and Corporate Transparency Act, it's an act that could have and should have been passed, or at least bits of it could and should have been passed 100 years ago. It was one of a series of statutes which were passed in the period 2010 through till last year. They are largely politically uncontroversial. The Bribery Act, which Lisa mentioned a moment ago, was initiated under the Labour government of Gordon Brown just after the banking crisis of 08-09, and it completed its passage through Parliament in 2010 and came into force in 2011. So it straddled two governments, and there was not a single vote in the House on that Act of Parliament, because by and large, most members of Parliament think that preventing bribery is not a bad idea. The kernel of the bill, the most important part of that 2010 Act, was the failure to prevent fraud offence. The failure to prevent bribery offence, which affects corporates that fail to prevent their associates, could be anywhere, committing substantive bribery. I, at the time, was very keen on developing the British response, the British government response to fighting economic crime. And I was having to do it at a time when the United Kingdom's ability to spend money on these sort of things was severely hampered, as I dare say it is at the current moment. And each government department was going to have to come up with 25 to 30% savings in its annual budget. And the Serious Fraud Office, which I supervised as a law officer, had a budget of £40 million, and it was going to go down to just shy of 30 million. And when I went to see Cyrus Vance, the New York State Attorney in the Southern District, I explained to him I want to learn about deferred prosecution agreements because I need to find a pragmatic and just way of doing cheaper and quicker justice against corporations. And he said, "What number did you say? 30 million?" I said, "Yes, 30 million. So that must be just for one office." So I said, "No, that's for the entire jurisdiction." And he sort of roared with laughter. And he said, "I spend more on flowers at home than that." And so you can see that the limits, the financial limits that Lisa and her predecessors and I were operating under. But you can also see we were operating under this Victorian directly minded will principle, the identification principle, which is how you render a corporation liable in criminal law. Now, in the Victorian era, if a mill or a small business was incorporated, and it probably wasn't, but if it was, the chances are it's going to be run by two men, two brothers, a brother and a brother-in-law, something like that. So finding out where the directly minded will of that company was, if it was cheating the revenue, it was not difficult. But now, look around us. You act for, you represent, you work in corporations which have literally tens of thousands of employees at various levels all around the world. And as Lisa just so sharply identified, in a case like Barclays, an enormous global corporation, if you try and render the corporation liable through the wrong board member, the case collapses. And it was struck me, and I'm sure it struck Lisa and many of her colleagues, it was plainly bonkers to see a company, and it's been justly acquitted, of course, to see a company committing criminal offences through not the agency, but through the persons of its senior managers, not being brought to justice. And it struck in my gullet, and I think it struck in the public gullet, that companies which were misconducting themselves in the context of the 2007-8-9 banking crash, there was a need for the public to see that something was going to be done about it. And so during the deliberations on the Crime in Courts Bill of 2013, which introduced deferred prosecutions into England, I tried to invite Parliament and through Parliament the government to allow for the American quasi-vicarious liability system for criminal liability for corporations. I was told it was the wrong time, and anyhow, it was the wrong bill. That's always the answer. It's the wrong time and it's the wrong bill, but they'll come along another opportunity. I then tried again under various criminal justice bills, and I tried again under the Criminal Finances Act of 2017, which introduced the failure to prevent the facilitation of tax offences. And then I tried again in the Economic Crime Bill of 2022, which was essentially about dealing with Russian dirty money following the invasion of Ukraine. And I tried again in the 23 Act, which we're touching upon here. And to some extent, I've made a little success in that we now have what's called the senior management offence. And I won't bore you with the detail, but it's for those of you who can't sleep at night, it's section 196. It's not a very long section. It's I can assure you, you'll be asleep before you've got to the end of the first line. So try it. But essentially, what it does is it makes a nod at the American system and tries, whilst pretending not to bring the United Kingdom into somewhere near the 21st century as far as corporate criminal liability. I think it's one of the biggest changes we've seen in 100 years. As you know, the Americans dealt with this by judicial act, by a judge's decision in 1912. We've had to wait another 110 years to get a half-hearted attempt. But what it does now is it renders a corporation criminally liable when a senior manager acting within the actual apparent scope of their authority commits criminal offence. And again, Schedule 12 of the Act sets out about 20 paragraphs of economic offences. I won't bore you with those, but you can obviously imagine what sorts they are. Now, what's a senior manager? A senior manager is an individual who has a significant role in decision-making of the whole or substantial part of the corporate, or who is involved in the actual management of the whole or part of the corporate. And department directors, other roles could include regional managers. Senior managers is not a clearly defined term, and so it may be difficult for corporations to work out who they are. But I suspect they're easier to recognize than they are to define, and it puts the burden on the managers of companies and the compliance officers of companies to go around their organogram, identifying potential senior managers, and then calling them in for an interview without coffee and saying, no crimes, please, because it could make a nasty day for the rest of us. As I say, there are a number of offences which come within the Act which can be caught by this. There is no defence, as there is, as Ben will tell us in a minute, about failure to prevent. There's no defence of reasonable or adequate procedures. And the body corporate or partnership that whose criminal liability is in play includes those companies incorporated outside of the United Kingdom. So it means that a non-UK company could be liable where an offence is committed by a UK national senior manager. But equally, it can be, it works if a foreign national, who is the senior manager, commits the offence within the United Kingdom. So there's a crossover, which people need to be careful of. And it leads to unlimited fines and obviously, as one of you just mentioned now, Dan, you can't send a company to prison, but you can fine the pants off it. This, I think, is the most significant change in the law for some while. The failure to prevent fraud offences, which I think Ben will talk about in a minute, is another such change. But I suspect that the elephant in the room that nobody has noticed is the senior manager liability, which came into force on the 26th of December 2023. So it's in force. So those of you who are worried about it will get even more worried about it because it's live. That's, I think, where I'll stop it for the moment, and it may well be that we can juggle it around as we move forward.
Thank you, Edward. That's extremely helpful. And what you've heard there is the general position in the UK around brick holding company libel has moved on in a way that a lot of independent observers would say was definitely necessary. Another thing that the act that we're talking about does, though, is create a brand new independent offence, which you've heard trail just now, the failure to prevent fraud. And that comes into force later next year, so keep your eyes peeled for that. That appears in section 199 of the Economic Crime and Corporate Transparency Act, and it introduces a strict liability offence for large organisations who fail to prevent criminal fraud if the organisation was the intended beneficiary. And it is a very significant development in the UK. As Lisa said, the Bribery Act had an enormous impact in the UK. And I was at the Serious Fraud Office prosecuting those cases as they started to come online, and there was an incredible energy and engagement in the market from companies within law enforcement around that time. And I think it's true that has tailed off somewhat. Those cases continue, but other cases can report or if they are, they're not succeeding. And so there's a question as to whether this is the thing that brings the rising tide up to a sort of similar stand across the board, as opposed to just that quite strange skyscraper on the landscape that was the Bribery Act on its own. And we'll see if that's what happens. So I'm just going to very briefly explain what that is, and then we'll go through some of the detail of it as a panel, and you can understand how it might work in practice. As I've said in a nutshell, companies will be exposed to the risk of investigation, and don't underestimate simply the risk of investigation, let alone prosecution. And prosecution if they're the intended beneficiaries of fraud committed by an associated person, which we'll come on to, but is really one of your employees or a third-party agent, for example. If, as Edward has said, the company didn't have reasonable fraud prevention procedures in place, and we'll unpack that a bit more as a panel. In terms of who does this offence apply to, the Bribery Act applies to any company. The failure to prevent fraud offence does not, but I think for people who advise or represent or are at companies in this room, it's probably going to be you. It applies to any large organisation, and that's defined in the Act as a company that has 2 out of 3 characteristics, or all 3. And the first is that it has more than 250 employees. The second is that it has a turnover of more than £36 million, and maybe you can tell us how that number was related upon. It's a very precise number, but I think if I've got this right, that's around 7 billion yen, if that's helpful. And then the third component is that it either also or instead has more than £18 million in total assets. So if those apply, then that's where the company is in scope. And I should say that this is purely a corporate offence. It doesn't apply to any individuals. So if that's the kind of organisation that is in scope, the next question is where, like, what's the jurisdictional point here? Like, who really needs to worry about it? And obviously anything going on in the UK, British companies, British people, very unsurprisingly that is in play. But also more concerningly, I suppose, for an international market, the Act is framed such that if you follow it through to its most technical analysis, you could have, for example, a Japanese company as the defendant that's having a problem here, that has a Japanese associated person who's committed the fraudulent offence, and both of those entities have done nothing physically in the UK. And even in those circumstances, if you follow the theory of liability that the Act contains, that company could be prosecuted in the UK for this offence, and that would require the additional step of the intended victims of the fraud being in the UK. And that's obviously why the UK cares, because they're looking after their victims. But it is in the same way that the Bribery Act was very international in its impact, it's something that, at least on paper, has an incredibly broad scope. Now, I wouldn't be surprised if Lisa's successor takes a less risky first case than that in terms of jurisdictional analysis. And then the last thing I'll say at this point is just thinking about fraud itself. The Bribery Act worked well because I think everybody readily understood and does understand what a bribe is. You see it, you recognize it, it's a brown envelope or a version thereof. And fraud, of course, is altogether more nuanced than that. And the difficulty, I think, for businesses is being really clear about what are their people doing in the ordinary course of their business, that if they go on to do it dishonestly, actually amounts to a fraud. And really a fraud is just the sense of saying something that isn't true, doing that dishonestly and doing it in a way that's intended to cause a loss or a gain. That if you think about, I don't know, a well-meaning ESG department that's making representations about what its company is trying to achieve in that very important space and projecting that to the market, hopefully so that investors are on board, so that counterparties want to engage with them. That's all good if it's true. If it isn't true, arguably those could be fraudulent statements. And if that's the case, so this ESG department, not the sales guys out in the difficult part of the world, are making dishonest statements in that respect, then the company could face corporate criminal liability for the first time in the UK. I'll pause there. There's lots to say about the act, but we're all going to unpack it together.
Well, Ben, thank you very much for your explanation about failure to prevent fraud offense, or in a very detailed manner. And I understand that, or through the associated person concept, that law could be, or that crime could be very broadly applied, not only in the United Kingdom, but also or anywhere in the world through that associated person. And on the other hand, or this claim is named as failure to prevent fraud offense. And is there any possibility of expanding this, or what this particular, or claim offense can cover, or is it limited only to the corporate fraud cases, or can we expand to, or more broader offenses in the future assignment?
Well, let's address how broad this is. The current director of the Serious Fraud Office has said that this legislation is the most important tool in over 10 years in terms of investigating and prosecuting corporate crime. Well, I'm sorry to say that the current director of the Serious Fraud Office is wrong. This is undoubtedly the most important tool for investigating and prosecuting crime in all of my career, and I have been practicing law for 35 years. I know, I've got a very good plastic surgeon. Edward has suggested that perhaps it is the most important and seismic development for 100 years. I agree, and this is why it's important for everybody with respect in this room to understand where we're at. What this does is brings us much, much closer to the US system. Previously, as Edward had explained, we were unable to prosecute in the United Kingdom many offences because nobody in the boardroom, nobody who was the directing mind of the will, left fingerprints or footprints in the boardroom. And it was virtually impossible, therefore, to impute their conduct to the company so the company could be prosecuted. And that was a big, big challenge for prosecutors. This law changes nearly all of that. So let's be clear to recap. 2 new offences. The first one is already in force. From the 26th of December, anybody who is a senior manager, and that's a very broad definition, if they commit a crime, the company can now be prosecuted. All of you have many senior managers all over the world at different levels, and understanding who they are and what they are doing is now fundamentally important because your organization, including outside of the United Kingdom, is capable of being prosecuted since December. Next year, as Ben has highlighted, we expect the failure to prevent fraud offence to come into force. We are waiting for guidance to be published by the government telling us how we can take advantage of the only defence to that law, which is to show that you have appropriate procedures in place. In other words, a compliance programme. But why is this also important? It's Ben's point, if I may. This is fraud. Fraud is kaleidoscopic. It's like a Rubik's Cube. It is so difficult to seek to define. But let me give you an example of just some of the offences that are covered by that broad definition within the Act, Schedule 13. Bribery is included. Fraud and dishonesty offences, theft, false accounting, tax evasion, sanctions, terrorist financing, money laundering. The stuff that happens in companies all day, every day, is now capable of being prosecuted against the company if your senior managers are implicated. And so this is huge. It really is important. Let's dwell just for 1 minute on what is the concept of fraud. We all understand the concept of making a false representation, telling lies, misrepresenting the truth of something. Well, there are other aspects of the Fraud Act. You can commit fraud by silence, by not revealing information, for instance, to an insurer or to an auditor when you are under a legal obligation to reveal that information. And you might commit fraud by abuse of position. All of this requires you simply to do one of two things, either to obtain a gain for yourself, the company, or to cause somebody else loss. These are really, really broad concepts, as Ben pointed out. And that is why I think this is probably the most important thing that anybody in this room has seen in terms of development in the United Kingdom.
Well, thank you, Simon. I think you mentioned that guidance for the failure to prevent fraud offense will be issued. And I think all this question should be addressed to Edward. Can you tell me when do you expect that guidance will be issued, and how that guidance would look like?
I wish I knew. This,
It's not his fault. He's not in the government anymore.
nothing was ever my fault. Unusually, in fact, this is a criminal offence which doesn't bite until guidance about it has been published. And the relevant government department produced a draft of it before the general election. The general election was in July. Some little while before that, they were circulating a draft of what the guidance might look like and invited interested parties to comment on it and so forth. And that was in the spring of this year, early part of this year. Not much was done about it because, frankly, the then government was getting into a drift and was not really achieving much in the way of implementing policy and so forth, and action. And I thought that the guidance would look very similar to the guidance under the Bribery Act, but with swap the word bribery for fraud offence. But I was wrong about that, as I have been about so many things in my life. But there we are. In September, I asked the relevant minister in Parliament who deals with fraud, when you're going to publish the guidance. And he was rather surprised because he hadn't really applied his mind to it. He'd been in office only for 6 weeks, and you've got lots of other exciting things to think about. And the fraud guidance was fraud guidance was not really on his list of things to do. And anyhow, he promised to go away and have a look at it. And he's still having a look at it, as far as I can see. I doubt it's going to be published in October. I think probably it will be published in November if we're lucky. But you've then got to wait 6 more months to work out when the offence will come into force. It demonstrates the sort of fudge and muddle of our legislative system in the United Kingdom. And it was demonstrated sharply during the course of the progress of the bill through Parliament, because you could ask as a non-government member of either the House of Commons or in my case in the House of Lords, I could ask the minister on the front bench, what's your policy about this, that or the other? Oh, well, I'll have to go away and think about it. Well, I always thought you never went to court without having thought about it first, and you don't go to Parliament and bring a bill without having thought about it first, but apparently I was being naive about that. The one thing I did want to invite you to think about was that, as Ben mentioned a moment ago, this failure to prevent offence applies only to large corporations, which he defined. I find that strange. I don't know about the United States and the states within the United States and in Japan, but in the United Kingdom we have a Theft Act, and it says that theft is a crime. It doesn't say only burglars over 6'6" are liable to be prosecuted for burglary. It says everybody who has committed the offence and is in the public interest to prosecute them is liable. And yet, with failure to prevent fraud, it's only large organisations. That is 0.5% of the corporate economy of the United Kingdom. So if you're in the 99.5%, which is not within the definition, happy Christmas. It is absurd. The response I got from the government, and I'm sorry to go off on a sort of anecdotal trip around Westminster, the response I got from the government is that to widen the ambit of the offence to all corporations would be a burden on business. Well, damn right it'd be a burden on business. If I take you to any prison in England, I'll introduce you to Fred Bloggs the burglar. Do you know what he'll say? That theft act, it's a real burden on burglars. It's got to go. And anyhow, it should only apply to 6'6" burglars, and I'm only 5'3". There is absolutely no logical basis for this narrowing of the offence only to large corporations, and I have yet to have a response which meets the logic of the question that is put to me. So this is, I'm glad we've got it, but it's too narrow, and the corporations which are going to be caught or are more likely to commit these offences are going to be the small startups with no compliance department, with fewer people to keep an eye on what the naughty salesman may or may not be doing. So I suspect that there'll be very few prosecutions of large corporations because they've got guys like you sitting around and saying, don't do it. Anyhow, that's the end of my rant on that particular subject.
Can I just add one thing?
please.
Oh, sorry, Simon, I'm talking. I just wanted to add that in terms of, it'll be a burden on business. When we started, when I realized how tough my job was going to be before I even took the chair, I started publicly trying to figure out whether we could get failure to prevent in an area other than when we had already seen it. UK Bribery Act, Criminal Finances Act, and was looking to do it in fraud because that was one of my scope of my work. And I can tell you, I had no fewer than 12 knockdown, drag out discussions with those in the Treasury and at the FCA, and all along the lines of, we've already got a rule here penalizing senior managers on the regulatory side. This will be a deal killer for business. I've now read commentary that indicates that maybe the Treasury would actually be interested in successful actions in this area, because guess what? As with DPAs, we didn't get to keep the money at the SFO. We wrote a £1 billion check to Rishi Sunak when he was head of the Treasury. So I'm gonna pull back now and let Simon add his, I'm sure, more insightful comments, but I thought it would be a helpful take on this. It's bad for business.
I'm not sure my comments are going to be more insightful. They may be a little startled. I was just a little bit surprised what Edward said when he speculated that perhaps there won't be too many prosecutions. I think that remains to be seen, because this is the tool I think prosecutors have been waiting for, and it might just represent floodgates. Bear in mind also that the test that we've spoken about doesn't relate to just single companies, it relates to group-wide entities, so it's easily satisfied. And I would suggest that pretty well every company that's represented in this room today is going to be affected by this, even if they are wholly outside the United Kingdom. I'd add one more thing. We are in an incredibly stressed global environment. We have Russia and Ukraine, we have the Middle East, we have China looking at Taiwan. We have incredibly high interest rates and economic stress. We are suffering 40 general elections on planet Earth. And as my old head of department said, when the tide goes out, the bodies surface. And that means that people and regulators and auditors and insurers and litigants and litigation funders have an interest to pick over the corpses. And when they do, in combination with whistleblowers and people who are wishing to get their competitors into trouble and share information, I think we have a unique and very heady mix that gives prosecutors an opportunity they never had before. Now that they have got the tools that Lisa was referring to, I'm very interested to see what will come. It may well be that there won't be too many prosecutions, but remember that as a result of the advent of deferred prosecution agreements, largely introduced by Edward, there is a new way of dealing with this, and that's to get the money. So the prosecutions might be the tip of the iceberg, but underneath we may have very many resolutions. And the final point to bear in mind is something that Ben touched upon. Even if you are not prosecuted, even if there is not ultimately a resolution by way of a deferred prosecution agreement, what we now have is a very new ability for prosecutors to kick down your doors, demand information and investigate you. And that is sometimes as painful as a prosecution.
And not to reiterate everything Simon just said, but one of the new features that we've seen in the UK is the ability of the SFO now to do very quick and dirty initial investigations of fraud under Section 2A. We used to only have powers under the in the corruption and bribery area, where we could just, streamline our investigation into an offense. We now have that. That's alive and well, or I guess it will be by the 15th of January, just around the corner, just after Christmas, where we'll be able to, where the SFO will be able to look at fraud cases in a way that will enable them not just to look for themselves, but to join hands with their foreign counterparts to make cases. So the likes of the folks you saw earlier are the very folks who might be the recipients of the kind of information that UK authorities are now able to get their hands on much quicker.
Well, thank you.
You have a question?
Oh,
Hi, yeah, I have a quick question, or actually two questions. I work for a German healthcare company, and I'm trying to triangulate whether I have a new problem I have to worry about in a significant way. So really two questions. First is, how do you define a significant corporate or a significant company? And number two, is there extraterritorial applicability of this legislation? And if so, is there some sort of nexus requirement? Thank you.
Yeah, absolutely. So we can answer both of those questions. You'd be pleased to know. So there is a very clear definition of a company that qualifies for this. If you look at section 199 of the Corporate Crime and Transparency Act, you can check it for yourself, but it's 250 employees or more. You need two out of these three things in that saying. So if you're already nodding, I can stop there. Turnover of more than 36 million British pounds or assets of more than 18 million pounds. And then in terms of the jurisdiction, so let's say your German healthcare company has absolutely no UK operations, which might be unlikely, but even if it doesn't, if anything that it does, that the people who are committing fraud on its behalf does, has as a victim somebody who is physically in the UK, then that would be enough of a jurisdictional hook. And I put it like that because that's a very extreme analysis, but it's true because that exists in the Act. And if you back up from there, anything that has anything like, for example, businesses, meetings that are conducted in the UK, or you actually do conduct business in the ordinary course in the UK, that obviously increases the robustness of the jurisdictional footing. But you don't even need that degree on my reading for the Act. I think probably quite non-controversial. Yes, yes, absolutely, yeah, of course.
I think the jurisdiction aspect is covered explicitly in the Act, and in essence, it applies to all large companies as defined by Ben, wherever they are incorporated. That is different from the Bribery Act. Under the Bribery Act, the test was a company that conducted business or part of the business in the United Kingdom. That rider does not exist under ECTA, and therefore it has a broader, potentially broader jurisdictional reach.
But it'd be the brave prosecutor who would take the first case where, for example, there wasn't a single UK victim, or something to give some color to the jurisdictional requirement. Not saying it couldn't be done, but it might not be the first case you read about in the Times of London.
Well, thank you very much. And based upon everything that you guys already explained, or can you tell me what the companies are currently doing or should do to prepare for this? Well, we already mentioned that or this law has two components. And the first one is already in effect from December last year, and the second one will be in effect, or 6 months after the guidance is issued. But under the current situation or circumstances, can you tell us what the company should do or what the company are doing to prepare for all this change? Perhaps Ben and Simon?
Good. Yeah, absolutely. So we can take both. So hopefully you've got the point that there's two different aspects to the Act. Both make corporate criminal liability more of a risk for businesses. We can take both, I think, in the same breath on this. What we're advising businesses to do, and there is a real range of pickup on that. I would say there are some highly resourced and self-aware businesses that are grasping for this information and trying to execute it, and others that are just ignoring it at the moment. I think there's that delta is going to really come into focus in the new year when the main fraud offence comes into force. But it's really not rocket science. The sequence of how do you get on top of this is risk assess, upgrade your policies to match the risks that you've identified, train the relevant people to understand that that's now the policy environment, and then test it and see if it's working. But as a number of people have commented on today, the risk assessment is probably the hardest part of that, because it isn't the case that you can go straight to your salespeople who are responsible for big projects who might or might not pay or accept bribes. You've got to think so much more carefully about the nuggets of the business that do ordinary different than the sort of front end things that could qualify as fraudulent activity. And when Simon's describing those are very helpful. Sort of unpacking of the different ways that someone can commit fraud, and I think the thoughtful part of the exercise is who are the people who do those things? How could they do them in a way that is improper? And if it's dishonest, how does that create the corporate criminal liability for us? And that takes more than a sort of a quick look. It's a very analytical exercise. Coupled with that, you're looking for who are your senior managers, to the point that Edward was making at the start. It is not, I think it's something that we all expect to be litigated heavily, and as a defence lawyer, I'll be saying that nobody is, of course. But a company will need to work out, well, in the past, only this board, as Lisa said, could be the people who bind us, and even then, maybe they're not. Now it's a much bigger pool of people, so who are they? Where do they sit within our organisation? And do they know that they can now create risk? And then the last thing I'd say is on the policy point, having now started to draft fraud policies with clients that specifically address those risks. And just as Edward said, it isn't a case of flipping the word bribe for fraud in what you've already got, because of what I was just describing, because of the different way that the risk presents itself. And this isn't just to sort of create lawyerly work, but such an exercise just doesn't match the risk. So it's a very much more thoughtful thing to build something that's bespoke to the problem that is now presented. So,
Simon?
I'd like to build on that. Remember, there are two key points here. One is the senior manager regime, which is already in force. You need to understand who your senior managers are and the type of frauds that they might be engaging in that could expose you to risk. You need to understand who might become senior managers in the near future, and identify people who work with senior managers who can be your eyes and ears to keep you safe. Because remember, there is no adequate procedures defense to this particular offence. And then, of course, as Ben said, look at your policies and your procedures and make sure you get the message out around the company, and do that now. The offence is in force. As regards the failure to prevent offence, well, we're waiting for the guidance. I would really strongly urge you not to wait in terms of your preparation. There is work that you can be doing now. Everybody on this panel can predict with some certainty what that guidance will obtain and the format that it will take. And so you need to get ahead of the curve, because I make this prediction. In 6 months' time, when that guidance is issued, there will be a mad rush for legal advice in the United Kingdom. And if we see what happened in relation to the Bribery Act, every lawyer that can spell the word "the" will claim to be a fraud expert and they have never been in a courtroom, even less a prison cell in all of their career. And you will get advice that is inexpert. It will be probably over-engineered. It will not fit your company and you will pay too much money for it. Get ahead of the curve, because the pool of people who are truly expert in the United Kingdom and have been doing this for 35 years or so is very small, I promise you. So what can you do? The key thing that Ben has pointed out, a risk assessment. It's an art form. Please don't do it internally. Please don't get your usual auditors to do it. This is highly complex legal analysis, and you do not want to over-engineer this. You need to understand what your real fraud risks are, who is likely to perpetrate them, where and how, and then and only then can you start to devise policies and procedures that will properly meet those offences. When you do a fraud risk assessment, it will be expected that you will put it into writing. Do not create a roadmap to all the risks and problems in your organisation that any number of people want to have a copy of. Not just prosecutors, so you can prove you've done your risk assessment, but your auditors and your insurers and your bankers and third parties will now want to know how you are addressing your risk, because this law is big news. So it's an art form, how you go about conducting a risk assessment. It's an art form, what you put in that risk assessment, and sometimes what you don't. And what we often see in the course of conducting a risk assessment are difficult issues. My advice is immediately hive them off into a more conventionally, legally privileged environment and get rid of that issue before it contaminates your fraud risk assessment. Last week, I was invited to do training for a huge Japanese company, and I think we trained potentially 100 senior managers. I think that's quite a large population. I was then invited to extend the training to the company. 1,000 people we trained last week. That company is pioneering. They are getting ahead of the curve because I think they understand very well indeed what these new risks represent. And they want to do it in an environment where they can relax and do it properly, rather than against the clock where they may make mistakes.
Well, thank you very much. And now it's 12:33, but and obviously I do not want to delay the lunchtime for everyone, but perhaps we can take one or two questions from the audience.
Of course.
They want their lunch.
Or if you want to do it over lunch, we're
Yes,
also
of
happy
course.
to take those questions. But if anyone is keen, don't be shy. I think I hear the vote for lunch.
Well, thank you very much, for paying attention to our presentation, and it would be great if we could give them a big applause.